This is HOA neighbor court. And I have the paper trail. A neighbor tried to hand me an old notice, and Karen screamed that passing documents was harassment. I measured it and you failed, Pamela Robinson shouted, waving a laminated policy sheet inches from my face at the mailbox cluster. The sheet had highlighting in tabs like a courtroom exhibit. She slammed a portable rolling stamp pad on the metal ledge between our mailboxes and pressed a notice onto it with both hands. The ink bled through the back. I work as a court interpreter. I know how hearings actually go. This was not one. This was Pamela Robinson, Rules Enforcement Chair for the Falcon Point Landing Association in Park City, Utah, turning the neighborhood mailbox cluster into her personal courtroom. Again. The notice said my contractor parked in a guest spot for 11 minutes during a bathroom remodel consult. The fee was $250, escalating to $500 if not paid within 72 hours. I had uploaded proof of the appointment to the HOA portal 4 days earlier. Pamela ignored that completely. She tapped the stamp pad twice more. You can appeal, but I do not negotiate with violations. Her voice carried across the entire cluster. 3 neighbors stood frozen with mail in their hands. One of them, the guy who lives in the corner unit with the pergola, had his arms crossed and a smirk on his face like he had seen the show before. I said nothing. I pulled out my phone and started recording. Pamela's eyes snapped to the camera. She stepped closer. That is intimidation. I confine you daily until you give up and you cry. The smirking neighbor coughed into his fist. Pamela whipped around and glared at him. He raised both hands and backed toward his front door, still smirking. I kept the phone steady. I already had one open dispute with the management company over a landscaping charge that appeared on my account 3 months after I paid it. Now Pamela was stacking new enforcement claims on top, and every single one targeted my guests or contractors. The parking warnings. The paint color complaint after I touched up my front door with the exact approved shade. The gutter cleaning notice 2 days after I had the gutters cleaned. It felt deliberate. Pamela snatched the notice off the stamp pad and shoved it into my hand. The ink smudged. 72 hours, she said. Then she turned and walked toward the management office at the end of the block, rolling the stamp pad behind her like luggage. I looked at the notice. The violation date was listed as 4 days ago. The upload confirmation email on my phone was timestamped 5 days ago. The timeline did not match. The smirking neighbor called over from his door. She did this to me 2 years ago. Parking thing. I paid it just to make her stop. Wish I had not. That stuck with me. I went inside and pulled up my portal account. The bathroom consult appointment upload was gone. The confirmation email was still in my inbox, but the file itself had vanished from the portal. I took a screenshot of the audit page. It showed my upload had existed, then disappeared. I opened my filing cabinet and pulled out the folder I had been avoiding for 8 months. Inside was a stack of notices from the year before, all targeting the previous owner of my unit. Parking violations. Landscaping complaints. A gutter cleaning notice. A paint color warning. Every single one had the same rolling stamp imprint in the corner and the same phrasing in the body text. The violations escalated fast. Fees doubled. A lien threat appeared. Then the owner sold and moved out in under 60 days. I had bought the unit from him at a discount because he wanted out fast. He never explained why. Now I was starting to understand. I pulled the new notice out of my pocket and compared it to the old stack. The stamp imprint matched exactly. The phrasing in the body paragraphs was identical, just with different dates and unit numbers. It looked like a template complaint stack. My phone buzzed. A text from the management company. Your guest parking appeal has been denied due to incomplete documentation. A follow-up lien notice will be issued if payment is not received within 72 hours. I had not even filed an appeal yet. I called the management company. The receptionist put me on hold for 6 minutes, then transferred me to a voicemail box. I left a message asking for clarification on the appeal denial and the missing portal upload. I also asked for a copy of the complaint log entries tied to my unit. No callback. I sent a follow-up email. No reply. The next morning, I found a new notice taped to my door. It was a landscaping violation. The notice said my front planter had unapproved decorative stone. The photo attached showed my planter from an angle that made the stone look larger than it was. The stone had been there when I bought the unit. The previous owner had installed it. The HOA had approved it in writing 3 years earlier. I checked the portal again. The landscaping approval document was gone. I stopped arguing and started collecting, because the endgame was already set. I printed everything. Every email. Every portal screenshot. Every notice. Every confirmation. I organized it all in a tabbed binder with section dividers and page protectors. I labeled each tab with a date range and a violation type. I made a second copy and stored it off-site. Then I went to the county recorder's office and pulled the HOA's financial disclosure forms for the past 3 years. Public record. I paid $12 for printed copies. The forms showed a line item called enforcement surcharges. The total collected over 3 years was $68,000. The forms also showed a separate line item called legal defense fund contributions. The total contributed over the same period was $62,000. The enforcement surcharges were supposed to fund common area repairs. The legal fund was supposed to cover lawsuits and insurance premiums. But the enforcement surcharge line item had a note in the margin that said collected, but not yet allocated. I cross-referenced the enforcement surcharge entries with the complaint log I had finally received from the management company after I filed a formal records request with a 7-day statutory deadline. The log showed over 200 violation notices issued in 3 years. Most of them were parking or landscaping complaints. Most of them targeted the same 6 units over and over. My unit was one of the 6. The previous owner's name appeared 41 times in 18 months. The log entries were written in a consistent voice. Short, clipped sentences. Excessive use of the word violator. Frequent references to non-compliance and failure to adhere. I compared the log voice to the notices in my binder. The phrasing matched exactly. Then I checked the log metadata. Every entry had a creation timestamp. I sorted by timestamp. 14 entries had been created within a single 6-hour window 3 months ago. All 14 were dated as occurring over a 6-month span the previous year. The creation timestamps proved the entries had been backdated. I grabbed my phone and called the smirking neighbor. He picked up on the second ring. "I need to ask you something," I said. "When you paid that parking fine 2 years ago, did you get a receipt?" "Yeah," he said. "Certified mail. Took 3 weeks." "Why? Do you still have it?" "Probably." "Let me check." He called me back 20 minutes later. Found it. The receipt is dated 2 weeks after I paid, and the payment amount on the receipt is $50 more than what I actually sent. I asked him to scan it and email it to me. He did. The receipt showed a payment of $300. His bank statement, which he also scanned, showed a withdrawal of $250 on the same date he mailed the check. I printed the receipt and the bank statement and added them to the binder. Then I called the tow company the HOA used for parking enforcement. I asked if they kept records of tow requests. The dispatcher said yes. I asked how long they kept them. She said 3 years. I drove to the tow yard the next morning. The clerk at the counter was a woman in her 50s with reading glasses on a chain. I explained I was trying to verify a tow request record tied to my HOA. She asked for my unit number and the approximate date. I gave her both. She typed into her system, frowned, and typed again. "We have a record of a request from your HOA," she said. But it was canceled before dispatch. The cancellation was logged as owner provided proof of authorization. I asked if I could see the request form. She printed it. The request was dated 8 months ago. The vehicle description matched my contractor's truck. The cancellation note said owner uploaded valid work order, but I had never received a tow threat for that incident. The notice Pamela gave me at the mailbox was the first I had heard of it. The clerk leaned closer. "This is weird," she said. "The request was submitted twice. Once 8 months ago, canceled. Then again 4 days ago, active. Same vehicle. Same location. Same HOA contact name." I asked her to print both requests. She did. I added them to the binder. The second request had a different reference number, but identical details. The submission timestamp on the second request was 30 minutes after Pamela handed me the notice at the mailbox. I went back to the county recorder and pulled the HOA's meeting minutes for the past 3 years. Another $12. The minutes showed that Pamela had been elected Rules Enforcement Chair 18 months ago. The vote was close. 3 board members voted yes, 2 voted no. One of the no votes resigned a month later and was replaced by a yes vote. The minutes also showed that the enforcement surcharge policy had been proposed by Pamela and approved in the same meeting where she was elected chair. The policy gave the chair unilateral authority to issue violation notices and set fee amounts without board approval, as long as the fees stayed under $500 per incident. I flipped through the minutes. Pamela's name appeared in every set. She proposed new landscaping standards. She proposed stricter parking rules. She proposed mandatory gutter cleaning schedules. Every proposal passed. Every proposal came with a new fee structure. Then I found the meeting minutes from 2 months ago. The topic was a budget shortfall in the Common Area Repair Fund. The treasurer reported that enforcement surcharges had been collected, but not yet allocated due to ongoing legal review. The legal review was never explained. No vote was taken. The topic was tabled. I checked the current HOA balance sheet. The enforcement surcharge line still said collected but not yet allocated. The amount was now $73,000. I called an attorney. I explained the situation. She listened, asked a few questions, and told me to file a formal complaint with the HOA board and copy the management company. She also told me to request an independent audit of the enforcement surcharge account. She said if the board refused, I could file a petition in small claims court to compel the audit under state HOA law. I drafted the complaint that night. I attached copies of the backdated log entries, the duplicate tow requests, the mismatched receipt, the missing portal uploads, and the financial disclosure forms. I sent it certified mail to every board member and the management company. I kept the originals in the binder. 2 days later, I got a response. It was not from the board. It was from Pamela. The email was short. "Your complaint has been reviewed and dismissed as frivolous. All enforcement actions were conducted in accordance with association policy. Any further complaints will be considered harassment and may result in additional fines." The email was signed with her full title. Rules Enforcement, Chair, Falcon Point Landing Association. I forwarded the email to my attorney. She replied within an hour. File the petition. This is retaliation. If you are enjoying this, hit subscribe and drop a like so you never miss another HOA meltdown. I filed the petition the next morning. The court clerk stamped it and told me the hearing was scheduled in 3 weeks. I paid the filing fee and got a receipt. I sent a copy of the petition and the receipt to every board member, the management company, and Pamela. The next day, I found a lien notice taped to my door. The notice listed 5 separate violations: parking, landscaping, gutter cleaning, paint color, guest conduct. The total amount due was $2,400, plus a $300 processing fee and a $500 legal review surcharge. The notice said the lien would be filed with the county recorder in 10 days unless payment was received in full. The legal review surcharge was new. I checked the HOA policy documents. There was no mention of a legal review surcharge anywhere. I called my attorney again. She told me to document everything and do not pay. She also told me to start recording every interaction with Pamela. I did not have to wait long. The next morning, Pamela knocked on my door at 6:45. I opened it with my phone already recording. She was holding a clipboard with a stack of notices. She did not say hello. "You missed the landscaping compliance deadline," she said. "I am issuing a daily non-compliance fine of $100 starting today." I pointed to the front planter. The stone was still there. It matched the photo from the original approval document I had printed from the county archives after the HOA portal version disappeared. "That approval is no longer valid," Pamela said. "The standards were updated last month." I asked to see the updated standards. She flipped through the clipboard and pulled out a single sheet. She held it up but did not hand it over. The sheet had a paragraph of text and a signature line at the bottom. The signature was hers. The date was from last week. I asked for a copy. She shook her head. "This is a draft. It will be finalized at the next board meeting." "So the standards are not actually updated yet," I said. "They are in effect as of my signature," she said. "I have enforcement authority." I stopped recording and stepped back. Pamela leaned forward. "You think you are clever," she said. "You think filing a petition makes you untouchable. It does not. I do not negotiate with violations. I can fine you daily until you give up and you cry." She turned and walked away. I saved the video and emailed it to my attorney. The attorney called me an hour later. "This is escalating," she said. "You need to document every interaction and start building a timeline. Also, check your phone storage. If you run out of space, you will lose evidence." I checked. My phone storage was at 87%. I backed up everything to a cloud account and deleted old apps to free up space. That afternoon, I got a text from the management company. "A board meeting has been scheduled for next week to address your petition. Attendance is mandatory." I replied asking for the meeting agenda and any materials I should review in advance. No response. I called the management company. The receptionist put me on hold, then transferred me to a voicemail box. I left another message. No callback. I decided to skip the management company and go directly to the board members. I looked up their contact information in the HOA directory. I sent each of them an email with the same question. "Can you provide the meeting agenda and materials?" 2 board members replied. One said the agenda would be posted 48 hours before the meeting. The other said the meeting was closed to non-board members. I forwarded both replies to my attorney. She said the meeting could not be closed if it was addressing my petition. She drafted a letter citing the state open meeting law and sent it to the board and the management company. The next day, the management company sent a revised meeting notice. The meeting was now open. The agenda included one item: discussion of owner complaint and petition. I printed the agenda and added it to the binder. The night before the meeting, I got another email from Pamela. It was sent to my address and copied to the entire board. The subject line said owner harassment pattern. The email was 3 paragraphs long. It accused me of filing false complaints, intimidating board members, and abusing the records request process. It included a list of every email and phone call I had made to the board and management company over the past 2 weeks. It called my behavior a coordinated harassment campaign. The email ended with a recommendation: immediate suspension of owner privileges pending a formal hearing. I forwarded it to my attorney. She replied in all caps: "Print this. Bring it to the meeting." The meeting was held in the management company conference room. I arrived 10 minutes early. Pamela was already there, seated at the head of the table with her portable rolling stamp pad on the table in front of her. She did not look at me. 3 board members were present: the president, the treasurer, and the secretary. The other 2 seats were empty. The president opened the meeting at 7. He read the agenda item. Then he turned to me. You have 5 minutes to present your complaint. I stood and opened the binder. I walked through the timeline, the backdated complaint log entries, the duplicate tow requests, the mismatched receipt from the smirking neighbor, the missing portal uploads, the enforcement surcharge account with $73,000 collected but not allocated. I showed the treasurer the financial disclosure forms. I showed the president the complaint log metadata showing 14 entries created in a single 6-hour window. I showed the secretary the email from Pamela dismissing my complaint as frivolous. The president stopped me. "This is a lot of information," he said. "We will need time to review it." Pamela stood up. "This is harassment," she said. "He is trying to intimidate the board with paperwork." I turned to her. "These are public records," I said. "You signed half of them." She slammed the stamp pad on the table. "I have enforcement authority. Every action I took was within policy." I pulled out the lien notice with the invented legal review surcharge. I held it up. "Show me the policy that allows this fee." Pamela flipped through a binder of her own. She pulled out a sheet and held it up. "Right here," she said. The sheet was the same draft standards document she had shown me at my door. The date was still from last week. The signature was still just hers. "That is a draft," I said. "It is not policy yet." "It is in effect as of my signature," she said. The president leaned forward. "Pamela, is this document approved by the board?" Pamela hesitated. "It will be approved at the next meeting." "So it is not approved yet," the president said. "I have enforcement authority," Pamela repeated. The treasurer cleared his throat. "I think we need to table this and review the documentation." Pamela turned to him. "There is nothing to review. He is a violator. He has been non-compliant for months." "I have the logs." I pulled out the printed complaint log. I flipped to the page with the metadata timestamps. I handed it to the treasurer. "These 14 entries were all created on the same day, 3 months ago," I said. "But they are dated as occurring over a 6-month span last year." "That is backdating." The treasurer looked at the page. He looked at Pamela. "Can you explain this?" Pamela snatched the page out of his hand. "This is a system glitch," she said. "The dates are correct. The timestamps are wrong." I turned to the treasurer. "The management company sent me this log in response to a formal records request," I said. "If the timestamps are wrong, the management company needs to explain why." The secretary spoke up. "I think we should request an independent audit." Pamela whipped around. "An audit is unnecessary and expensive." The treasurer nodded slowly. "I agree with the secretary. We need an audit. Especially if there are questions about the enforcement surcharge account." Pamela's face went red. "You are letting him manipulate you." The president held up a hand. "Pamela, sit down. We are going to vote on this." Pamela sat. She crossed her arms. The president called for a vote. All 3 board members voted yes. The motion passed. Pamela stood up again. "I am resigning. Effective immediately." The president blinked. "You are resigning?" "Yes," Pamela said. "I will not be part of a board that undermines enforcement authority." She grabbed her stamp pad and her binder and walked out. The door slammed behind her. The room was silent for a moment. Then the treasurer exhaled. "Well," he said, "that was dramatic." The president turned to me. "We will schedule the audit and notify you of the results. In the meantime, all enforcement actions against your unit are suspended pending the audit findings." I thanked him and left. I walked to my car and sat in the driver's seat for a full minute before starting the engine. My hands were shaking. I had expected pushback. I had not expected Pamela to quit on the spot. I drove home and emailed my attorney. She called me 10 minutes later. "This is good," she said. "But do not assume it is over. She is going to escalate." She was right. 2 days later, I found my car blocked in by a tow truck. The driver was hooking up the front end. I ran outside. The driver held up a hand. "I have a tow order," he said. "Unauthorized parking." I pointed to my assigned spot number on the curb. "This is my spot," I said. He shrugged. "I just follow the order. Take it up with the HOA." I pulled out my phone and called the tow company. The dispatcher answered. I explained the situation. She put me on hold. When she came back, her voice was clipped. "The order was submitted by your HOA this morning. Vehicle parked in violation of guest spot restrictions." "I am not in a guest spot," I said. "I am in my assigned spot." "Hold on," she said. She put me on hold again. This time, she was gone for 3 minutes. When she came back, her tone had changed. "Sir, I am looking at the order now. It lists your vehicle as parked in spot G7. Is that correct?" "No," I said. "I am in spot 42. My assigned spot." There was a pause. "Can you send me a photo of your parking spot number and your vehicle registration?" I took the photos and texted them to the number she gave me. She called me back 2 minutes later. "Sir, I am canceling this order. The spot number on the order does not match your actual location. I am also flagging this account for review." I asked her who submitted the order. She hesitated. "I cannot give you that information, but I can tell you it was the same contact who submitted the request we canceled 8 months ago." I thanked her and hung up. The tow driver unhooked my car and drove away. I stood in the parking lot with my phone in my hand and my heart pounding. Pamela had just tried to tow my car out of my own assigned spot. I called my attorney. She told me to file a police report for attempted theft. I called the non-emergency line. The dispatcher said an officer would come by within 2 hours. The officer arrived 90 minutes later. I showed him the tow order, the photos, the dispatcher's statement, and the duplicate tow requests from the binder. He took notes and photos. He said he would forward the report to the fraud unit. Then he asked if I felt safe. I said yes, but I was concerned about escalation. He gave me his card and told me to call immediately if Pamela showed up at my door or tried to contact me directly. That night, I got a text from the smirking neighbor. "Just saw Pamela at the mailbox cluster with a stack of notices. She was taping them to every unit that has ever filed a complaint. Thought you should know." I walked to the mailbox cluster. There were notices taped to 6 mailboxes, including mine. The notices were identical. They said the board had voted to suspend owner privileges pending a formal hearing. The hearing was scheduled in 10 days. The notice listed the charges: filing false complaints, harassment of board members, abuse of records, request process, disruption of HOA operations. The notice was signed by Pamela. Her title was listed as Acting Rules Enforcement Chair. I pulled the notice off my mailbox and called the board president. He picked up on the 3rd ring. "Did you vote to suspend my privileges?" I asked. "No," he said. "We did not even meet." "Where did you see that?" "There are notices taped to 6 mailboxes right now," I said. "They are signed by Pamela." He was silent for a moment. "She does not have that authority anymore. She resigned. The notices say she is acting chair." "She is not," he said. "I am calling an emergency board meeting tomorrow. Do not respond to the notices." I thanked him and hung up. Then I took photos of all 6 notices and emailed them to my attorney. She replied immediately. "This is defamation and fraud. Print everything. File an addendum to the police report. Do not let her control the narrative." I printed the notices and drove to the police station. The front desk officer took the addendum report and said someone would follow up within 48 hours. The next day, the board president sent an email to the entire association. It said Pamela Robinson was no longer a board member or officer of the HOA. It said any notices issued by her after her resignation date were void. It said the board had not voted to suspend anyone's privileges. It said an independent audit of the enforcement surcharge account was underway, and results would be shared within 30 days. I saved the email. Then I checked the mailbox cluster. The notices were gone. Someone had removed them overnight. The following week, I got a call from the tow company dispatcher. She asked if I could come to the tow yard. She said there was something I needed to see. I drove to the tow yard that afternoon. The dispatcher met me at the gate. She walked me to the office and pulled up her computer. She showed me the order history for the HOA account. There were over 60 tow requests submitted in the past 18 months. 43 of them had been canceled before dispatch. 17 had been completed. She clicked on one of the completed requests. The vehicle description matched the smirking neighbor's car. The date was from 2 years ago. The cancellation note on the failed request from 8 months earlier said owner provided proof of authorization. But the completed request from 2 years ago had no cancellation. It had gone through. I asked if I could see the paperwork for the completed tow. She printed it. The request listed the vehicle as parked in a guest spot without authorization. The tow fee was $375. The vehicle owner had paid the fee to retrieve the car. I asked if the HOA had submitted any documentation proving the vehicle was unauthorized. She checked the file. No documentation, just the request form. I asked if she could print the full order history. She did. I added it to the binder. Then I asked her the question I had been holding. If I show you a pattern of fraudulent requests, will you stop accepting orders from this HOA contact? She looked at me for a long moment. If you can prove it, she said, we will flag the account and require secondary authorization for any future requests. I pulled out the binder. I showed her the duplicate requests, the mismatched spot numbers, the cancellation notes, the backdated complaint logs, the enforcement surcharge account. She read through it all. Then she picked up the phone and called her supervisor. They talked for 5 minutes. When she hung up, she turned to me. We are flagging the account, she said. Any future requests from your HOA will require written authorization from the board president or the management company, with proof of violation attached. I thanked her and left. I sat in my car and exhaled. The tow threat was neutralized. But Pamela was not done. The next morning, I found Pamela waiting for me in the management company parking lot. She was standing beside my car with her arms crossed. Her portable rolling stamp pad was on the hood. I stopped 10 feet away and pulled out my phone. I started recording. You think you won, Pamela said. You think flagging the tow account makes you safe. I did not respond. I have been enforcing rules in this neighborhood for 18 months, she continued. I know every violation, every loophole, every owner who thinks they are above policy. You are not special. I asked her to step away from my car. She ignored me. The audit is going to show that every fee I collected was legitimate, she said. Every notice I issued was justified. You are wasting everyone's time and money. I asked her again to step away from my car. She picked up the stamp pad and slammed it on the hood. The ink left a mark. Then she walked to her own car and drove away. I took photos of the ink mark and the parking lot. I emailed them to my attorney and added a note. She is not stopping. My attorney called me 20 minutes later. File a restraining order, she said. This is stalking. I drove to the courthouse and filed the petition. The clerk gave me a hearing date 2 weeks out. I served Pamela with the petition through a process server the next day. She responded by filing a countercomplaint. She claimed I was harassing her. She attached the email I had sent to the board members asking for the meeting agenda. She attached the records request I had filed with the management company. She attached the police report I had filed after the tow attempt. She called it a pattern of obsessive behavior. The hearing was scheduled for the same day as my restraining order hearing. The judge consolidated both cases. The morning of the hearing, I got a call from the board president. The audit is done, he said. You need to see the results before the hearing. I met him at the management company office. He handed me a printed report. The audit covered 3 years of enforcement surcharge collections. The total collected was $79,000. The total allocated to common area repairs was $0. The total deposited into the legal defense fund was $62,000. The remaining $17,000 was listed as administrative processing fees. The report included a breakdown of the administrative fees. All of them were paid to a single vendor. The vendor name was PRM Consulting. The report included the vendor's business address. It was a P.O. box in a town 30 miles away. I looked up PRM Consulting on my phone. The business registration listed the owner as Pamela R. Mitchelson. Her middle initial was R. Her maiden name was Robinson. She had been paying herself administrative fees out of the enforcement surcharge account. I showed the board president. He stared at the page. She set up a shell company, he said. I asked if the board had ever approved payments to PRM Consulting. He shook his head. This is fraud. I took the report to the hearing. The judge reviewed it. Then she asked Pamela to explain the vendor payments. Pamela stood. PRM Consulting provides administrative support services to the HOA, she said. The fees are for processing violation notices and maintaining the complaint log. The judge looked at the report. Who authorized these payments? I have enforcement authority, Pamela said. The board delegated administrative tasks to me when I was elected chair. The judge asked the board president if that was accurate. He said no. The board never authorized any payments to an outside vendor. We were not aware of PRM Consulting until the audit. The judge turned back to Pamela. Do you own PRM Consulting? Pamela hesitated. I provide consulting services to multiple HOAs. That is not what I asked, the judge said. Do you own PRM Consulting? Yes, Pamela said. The judge set down the report. You were paying yourself out of the enforcement surcharge account without board approval. I was compensated for administrative work, Pamela said. That is not fraud. The judge looked at her for a long moment. I am granting the restraining order, she said. You are prohibited from contacting the petitioner, entering HOA property, or submitting any enforcement requests on behalf of the association. The court is also referring this matter to the district attorney for investigation of fraud and embezzlement. Pamela's face went white. The judge continued. The counter-complaint is dismissed as frivolous. The petitioner's records requests and police reports were lawful and appropriate. Pamela opened her mouth, then closed it. She grabbed her bag and walked out of the courtroom. The door swung shut behind her. The judge turned to me. I recommend you share this audit with every homeowner in your association, she said. If there are other victims, they have a right to know. I thanked her. I walked out of the courthouse and sat on the steps for 5 minutes. My hands were still shaking. I called my attorney. She answered on the first ring. We won, I said. I know, she said. I am already drafting a demand letter to the management company. They are going to refund every bogus fee. A week later, the board sent an email to the entire association. It included the full audit report. It included a summary of the judge's ruling. It included an apology for the lack of oversight. And it included a refund plan. Every homeowner who had paid an enforcement surcharge over the past 3 years would receive a full refund within 60 days. The refunds would come out of the legal defense fund. The board also announced new policies. All enforcement actions would require board approval. All financial transactions over $500 would require 2 board signatures. And the HOA would publish enforcement standards and timelines to all homeowners within 30 days. The email ended with a note. Pamela Robinson is no longer affiliated with the Falcon Point Landing Association in any capacity. Any correspondence from her should be reported to the management company immediately. I printed the email and added it to the binder. Then I closed the binder and put it on the shelf. 2 weeks later, I got a check in the mail. It was a refund for $2,400 plus the $300 processing fee and the $500 invented legal review surcharge. The check memo said enforcement surcharge refund per board resolution. I deposited the check. Then I called the smirking neighbor. He picked up on the second ring. "Did you get your refund?" I asked. "Just open the envelope," he said. $350. I did not think I would ever see that money again. "The board email said they are refunding everyone," I said. He laughed. "Pamela is probably losing her mind." "She is also being investigated for fraud," I said. "Good," he said. "She deserved it." A month later, the district attorney filed charges. Pamela Robinson was indicted on 3 counts of fraud and 2 counts of embezzlement. The case was assigned to a grand jury. The trial date was set for 6 months out. The board president called me the night the charges were announced. "I wanted to thank you," he said. "If you had not filed that petition, we never would have known." I told him I was just protecting my own unit. "You did more than that," he said. "You protected the whole neighborhood." I hung up and walked to the mailbox cluster. It was empty except for one neighbor checking her mail. She looked up when I approached. "You are the guy who took down Pamela," she said. I nodded. She smiled. "My daughter got a refund for a landscaping fine from 3 years ago. We thought that money was gone forever." "I am glad you got it back," I said. She closed her mailbox. "A lot of people here are glad you did not give up." I walked back to my unit and sat on the front step. The planter with the decorative stone was still there. The gutter cleaning was up to date. The paint color matched the approved shade. Everything was exactly as it should be. Pamela's portable rolling stamp pad never showed up again. The complaint log was scrubbed clean and rebuilt from scratch with proper timestamps and board oversight. The enforcement surcharge account was dissolved. The tow company kept the HOA account flagged. And I kept the binder on the shelf, just in case. 6 months later, Pamela Robinson was convicted on all 5 counts. She was sentenced to 18 months in prison and ordered to pay restitution of $79,000 to the Falcon Point Landing Association. The judge also imposed a 5-year ban on serving in any HOA leadership role. The board president sent me a copy of the sentencing order. I printed it and added it to the binder. Then I closed the binder and put it back on the shelf. The neighborhood is quiet now. The mailbox cluster is just a mailbox cluster. The parking lot is just a parking lot. The rules are still there, but they are enforced fairly. No one gets targeted. No one gets railroaded. No one has to pay just to make it stop. And every time I walk past the spot where Pamela used to slam that stamp pad on the metal ledge, I remember the exact moment I decided to stop arguing and start collecting. Because the endgame was already set. Thank you for spending your time with me.